Ask Reddit. Lawyers of Reddit. What is a detail that your client failed to bring up to you that completely lost you the case? Part 1. Opposing counsel. Isn't it true you hit victim in the face with a brick? Client. No, Marcus hit him with the brick. I hit him in the back with a piece of wood. To be fair. He'd sent a photo of his wife's beaten face to his wife with a message saying something along the lines of this: "Do you want this to happen again?" He came across very well in court up to that point, but his mask slipped when that came out. Yeah, sounds like someone I know. He can keep the mask on for a while, but it starts to slip when his perceived world isn't reality. A buddy of mine came as a public defender. A gal was busted on drug charges and told him she didn't have any drugs on her when they arrested her. He thought, okay, we'll use that. Turns out she didn't have any drugs on her when they arrested her because she just sold them to an undercover cop. Well, technically. Just kidding. I do wonder though if she was actually smart enough to think of that on her own, or was she just being stupid? Well, I guess technically she was being stupid either way. LOL. My house was robbed. In addition to all the stuff that the thief took, he also stole a bunch of my suits and all my neckties. I had a big collection, like 100 or so. However, the thief left fingerprints on a hard plastic box that I kept spare change in. Fast forward 3 months, the thief is caught in the act of robbing another house in the same neighborhood, same detectives on my case as the new theft. They fingerprint the guy and the fingerprints match the ones from my house. At the thief's arraignment, I see him stroll in wearing my suit and my tie. I tell the district attorney. He says there's really no way to prove it. However, the tie he chose to wear was a one-of-a-kind street map of San Francisco, and I still had all the documentation to prove it. The district attorney's eyes widened and he informs the judge. The judge has the thief placed under arrest again for possession of the stolen property. The thief's lawyer was dumbfounded. It was a nice end to a rough situation. Custody case. The client failed to tell me he was previously convicted of felony child abuse for breaking 16 bones in an infant's body. Sometimes I wish we could just stone people. I've often thought about how satisfying different sadistic punishments would be, but then realized that if you were to actually do something like that, then you're not really much different from the person you're punishing. Just give them a shot and put them down like a sick dog. Little late to the party, but here goes. And obligatory, not my client. The company I worked for at the time was doing due diligence before acquiring a small tech startup. The COO of the tech startup was a well-liked guy in the company, friendly and outgoing. Though we heard rumblings that the COO was rather hands-on with the work and with the female employees. Apparently there was a walkaway package proposed to the COO that would let him keep a sizable portion of his post-acquisition bonus because a young woman who worked in their sales department had filed HR complaints against the COO and obtained counsel. I sat in on the meeting with the COO and the company's retained lawyers while they grilled him about his contacts with the young women. The COO denied ever having contact with her within the company without multiple other people present. Those people said his behavior toward her in the meeting didn't raise any flags. The COO empathetically denied having any contact with her outside of work. The lawyers asked the question a half a dozen different ways, and each time the COO denied any out-of-work contact. Later, we met with the woman and her lawyer with the COO not present. Her lawyer gives us a rather graphic card that came with a bouquet of flowers addressed to her from the COO. The guy had an account with a florist linked to his credit card. When the company retained lawyers confronted him and he said, "But I never had contact with her. It's not like I delivered the flowers myself." COO got terminated for cause, so no walkaway package. At her request, the woman was given PTO until after the acquisition, then moved to another one of the companies under our umbrella. Lawyer in the UK. I acted for a member of a famous pedophile hunting group. My client was charged with various offenses relating to his vigilantism, most seriously causing grievously bodily harm with intent. He wanted me to fight the case on a public interest offense point that is not available to him in statute or at common law, contrary to my advice. I followed his instructions as I'm bound to do. If the state won't punish pedophiles properly, then it's left to men like my client to take the law into their own hands. A horse-dung argument for a whole host of reasons. His laptop was seized by police and submitted for forensic examination. He had a staggeringly huge database of child pornography on it. He himself was a massive pedo. Minor traffic cases can be the worst for this. Believe it or not, because they are short and simple, and oftentimes the client isn't there, so if you get blindsided by something critical, there's often no chance to consult with them to turn things around. I had a simple speeding case, 70 miles per hour in a 55. No big deal. If she does a driving improvement course, the court will usually dismiss or reduce those, since her driving record wasn't bad. When I showed up for her, I found out that she had been driving 70 up an unplowed snow lane to get around all the other cars traveling in the lane that had been plowed because they were driving too slow. I didn't know it was even possible to drive 70 on fresh snow. The officer stated he'd already cut her a break by not writing the ticket for reckless driving, and the judge politely agreed he didn't feel comfortable reducing it under those circumstances. When I called her up after court to confirm, she did. Claimed she'd just forgotten to mention it. Now, maybe I've lived too much of my life in the South, but that just boggles my mind as a detail you'd forget when hiring a lawyer for that incident. I would have told her in advance that hiring us was a waste of money, not to mention the hassle of taking an 8-hour class, and she should probably just go ahead and pay this one. I legitimately do that all the time during consults. Give my honest assessment if the case is even worth doing, and so by admitting the detail she harmed herself for no reason. At least she took it well and didn't get defensive. Friend of mine is a defense attorney. He was representing a guy with a lengthy record for assault. Basically, this guy took an AC unit and threw it at his girlfriend. My buddy tells me he was able to get a plea deal for 1 year probation, no jail time. The judge is all ready to accept the deal when he asks the defendant if he had anything he would like to say. The defendant responds, "Yeah, I don't know why they're charging me with assault. I never touched her. I just threw an AC at her." This is nonsense. Judge rescinded plea deal because of defendant's attitude and lack of remorse. Went to trial and got a year in jail. The idea of having an AC unit thrown at me is honestly terrifying. Client said his ex owed him a lot of money and that she was trying to get out of paying him back by getting a protective order against him. Seemed reasonable, so I took his case. At the hearing, it came out that they were never a couple, that he was sending sex toys to her residence on a weekly basis, and that she never asked for thousands of dollars he gave her over the years. Stripper. We lost. He got laughed out of court, and he learned a valuable lesson. Tell your lawyer the good and the bad stuff before the trial. That he filmed his offenses for his YouTube channel. The cops didn't even know. A witness brought it up on day 3 of a trial. It was a nice quick change of plea that afternoon. So you're saying it's just a prank, bro, isn't a valid legal defense? Not since Prankster versus Bro in 1986. There's so many. My dude in a custody battle where the opposing party claims he has a drinking problem and he denies it 1000%. Even after the real talk I have with him, asking him to not hide things from me and to be honest, we go into court, and at cross-examination, the opposing party provides video evidence of him finishing work, driving to an abandoned parking lot to drink a few tall boys, and then going to pick up his kids from school. Every single access visit. He not only didn't tell me that, he forgot to mention that his ex-brother owns a private investigating firm. Idiot. It's clearly not a problem. I have time to stop and leisurely drink a few. It's no trouble at all. Man, already have the deck stacked against you and decide, hey, let's play divorce on hard mode. Case is a paralegal. Negligence case. Client argued that a lack of streetlights and a cyclist he couldn't see was responsible for him hitting a wire pole. Upon discovery, the first respondent's report indicated that they found the driver in the driver's seat, pants down, with porn playing on the phone. Wasn't difficult to figure out who was negligent at that point. Your Honor, if the cable repairman had simply fixed the cable in accordance with the professional standard practices, my client would have had no other recourse but to keep his ostrich in the corral on the evening in question. Guy in prison hired me to request a modification of his sentence because he was doing very well, completing a lot of optional programs, no rule violations, etc. He had his family come in and pay and everything to get started. I asked the family and the client if he had requested modification before, because the law said that for his conviction, he could only request modification twice for any one sentence, regardless of if they were granted or denied. Swore to us up and down he'd never filed before. You can see where this is going. After spending a few hours going over records and preparing documents, a copy of the CCS, the case record basically, finally arrived. He'd personally filed for modification 6 times since he was arrested with handwritten pleadings that were all denied. So the one he hired me for was the waste of time and would never be considered at all. Employment case. We get to the deposition of my client and all set up. The first question is, please state your name. The client looks at me and says, can we take a break? We do, and she pulls me out into the hall and tells me she's lied to me about her identity. She's apparently a serial fraudster and has changed identity 7 times since the 90s. She apparently thought the other attorneys had somehow figured it out, and that's why they asked the question. I've got a Mr. Poe on line 2. Something about a heart? I'm a court-appointed attorney for qualifying individuals and family matters. Termination of parental rights case. Have been fighting to argue that parent is stable, working lawfully, has a suitable apartment, doesn't need psychotropic meds anymore, ready to be a parent, etc. After a few months of negotiating with all the parties and Department of Children, Court Services, we have a pretrial to try and convince guardians. I met with my client before the hearing to see if anything changed. Nope, all good. Let's get my kids. Great, that's not happening today, but let's try. We get going in court. My client, who is super hot-headed and quick to anger, gets riled up and goes off on the guardians, screaming in open court. It doesn't end there, but reveals 1, that no longer is working, 2, no longer in apartment, 3, doesn't want to have a relationship with the guardians despite her kids loving them, 4, won't send her kids pictures of the toys they miss and can't have, 5, plans on moving out of state, 6, thinks they can live as a family off of state aid when she gets them back, and is 4 months pregnant. All in the matter of 15 seconds. I was too shocked to even react. Speechless. Not the image of stability and parental fitness I've been trying to paint since last July.